You okay? Yep. All right. For those of you who are new to the audience, as some of us are new to the chair, she's the one that keeps me on the straight and narrow. And so I would like to call on Administrative Staff Kluge to call the roll, please.
Chair Sangri,
Here.
Vice Chair O'Connor,
Here.
Commissioner Dews,
Here.
Commissioner Bates,
Here.
Commissioner Leek,
Here.
Commissioner Mino,
Here.
Commissioner Lindstrom.
Present.
Thank you. We have a quorum, and we do not have a representative from City Council this evening, and so we will move on to the agenda, which I will ask first. Does anyone have, any of the commissioners have concerns or changes to propose in the agenda?
No.
Okay, hearing none, we'll go to the minutes. And before we ask whether anybody else has a change, I'd like to request a small editorial change under the major heading Schedule Review and Management Update. There was a description of this meeting that said we are going to have a hearing for a Type 2 tree removal permit and a hearing for a 2-parcel minor petition that's on appeal. I think the on appeal really applies to the first of those two meetings and not the second. And so if there are no objections, I'd like to suggest that that change be made.
Sorry, I do want to, sorry, Manager Hasty, I want to make a quick correction. The land use application has been appealed.
Oh, so they're both on appeal.
Yes, they are. Yeah.
Sorry, then I'd like to make a different suggestion, put on appeal twice. Okay, are there any other changes to the minutes? Can somebody move their acceptance as amended?
I move to accept the minutes from the July 15th, 2024 DRC minutes as amended.
I second.
All those in favor, aye?
Aye.
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 Okay. We do not have any findings to deal with. We do have two public hearings this evening. And so I would like to open up the first of these hearings, and it concerns a, here we go. It concerns a removal of two trees at 1405 Eldenberry Court. And it is our file number 2400308. And I'd like to begin this by having our city attorney review with us and the participants the process for this hearing.
Thank you, Mr. Chair. The hearing process is as follows. First, there'll be a presentation by staff, then testimony by the applicant, up to 20 minutes, then testimony by parties in support of the application, then testimony by parties opposed to the application, and finally testimony by those neither for nor against the application. Individuals will be allowed up to 5 minutes. Any person in attendance may cede his or her time for testimony to another person, except to the applicant. But in no case shall any person's testimony be increased to greater than 10 minutes. Recognized neighborhood association, homeowner associations, government or government agencies, or other incorporated public interest organizations will be allowed up to 10 minutes. The time limits do not include time spent responding to questions from the commission. Testimony by attorneys, representatives, and witnesses on behalf of or which are part of the presentation by a person shall be counted within that person's time limit. It is assumed the person is testifying on their own behalf unless they expressly identify the recognized neighborhood association, homeowner association, government or government agency, or other incorporated public interest organization they are representing. After testimony in favor, opposed, and neither for nor against, then the applicant's rebuttal up to 5 minutes, followed by commission deliberation. A statement to the commission will be given by the commission of any proposed conditions of approval, if different than contained in the staff report, if any, not in this case by the staff, and the applicant's response to the commission's conditions of approval proposed following commission deliberation. As stated in the public notice, the deadline for submission of any written materials was noon today. No written materials may be submitted to the commission tonight. This tree removal request is to be considered based upon the applicable criteria and standards. The staff report lists the criteria and standards identified by staff as applicable to the request. It was available online and from the planning department. Testimony and evidence must be directed towards the applicable criteria. We ask that you specifically identify to the commission the criteria standards you're addressing so the commission may consider testimony in relation to the criteria standards. If you do not identify the criteria standards you're addressing, the commission is not obliged to guess which standards or criteria you're testifying about and may not consider your testimony in its decision. Failure to raise an issue accompanied by statements or evidence sufficient to afford the commission and the parties an opportunity to respond to the issue precludes raising the issue to the city council and on appeal. The failure of the applicant to raise constitutional or other issues relating to proposed conditions of approval with specificity to allow the commission to respond to the issue precludes an action for damages in circuit court. A potential conflict of interest is declared on behalf of each of the DRC members to the extent of their business or employment, which each will identify. Unless declared otherwise, the respective DRC member does not have a known present or anticipated future business relationship with the project or the applicant. It is possible that a future business relationship could arise in the initiation, design, construction, or maintenance of the project through either the employment or business of the DRC member personally or through a relative as defined in ORS 244-020. At this point, I would ask the commission members to please declare if you've had any ex parte contacts, including a site visit, if you're biased on the application, any financial conflicts of interest, and please state your business or employment. Commissioner Mino.
My name is Yuko Mino. I'm an architect. I have not visited the site. I do not know the parties involved, nor have I had any ex parte communication. I do not have a financial interest or a conflict of interest in this case. I do not have a bias.
I'm John Dews. I'm a retired architect. I have not visited the site. I have not had any ex parte contacts, nor do I have any bias or financial conflicts of interest.
I am Helen Leek. I am a realtor. I know exactly where the site is because I live in the neighborhood. I have not had any ex parte communication. I do not know the parties involved. I have no financial interest nor conflict of interest in the case, and I do not have any bias.
I'm Dwight Sangre. I'm a retired civil engineer. I also live in the neighborhood and do know where this site is. I have not visited the site. I have no relationship, business or otherwise, with any of the parties involved. I have not had any ex parte communication regarding this, and I do not consider I have any bias.
My name is Russ O'Connor. I'm a retired senior project manager. I have had no ex parte contact. I am familiar with the site. I have no bias, no financial contact. Did I leave one out?
That's
I
good.
think that's it. Thank you.
My name is Larry Lindstrom. I'm a construction executive here in the state of Oregon. I have not visited the site. I have not had any ex parte communication. I do not know the parties involved. I do not have any financial interest or conflict of interest in this case, and I do not have a bias.
My name is Kristen Bates. I'm a real estate attorney. I have not visited the site. I have no financial interest, no conflict of interest, no ex parte contacts with the parties, and I do not have any bias.
Thank you. Is there any challenge to Commissioner's right to consider the application? Seeing none, Associate Planner Daphne Sissel with the staff report, please.
Good evening, Commissioners. My name is Daphne Sissel, Associate Planner with the City and Staff Coordinator for this tree removal application. This hearing is regarding tree removal application 499-24-000308-tree for 14052 Edenberry Court. As discussed in the staff memo dated August 1st, the following exhibits were added to the record: F7 through F12 and exhibits G1 through G4. Issues raised were addressed in that memo. The Type 2 tree removal application is requesting the removal of 2 Oregon white oaks measuring 23 and 25 inches in diameter. All Type 2 applications must meet the Type 2 criteria for issuance under Lake Oswego Code 55.02.080 to be approved for removal. Criterion 1 is the reason for removal. The applicant marked both outgrown landscape area and landscape plan improvement. For the purposes of this section, a tree that has outgrown its landscape area may include, but is not limited to, a tree that has grown such that damage to a structure or facility cannot be avoided by pruning or other maintenance. The applicant did not submit supporting evidence that the trees have outgrown the landscaping area, and no infrastructure damage was observed by the city's contract arborist or by staff. For the purposes of the landscape plan improvement reason for removal, a landscape plan shall consist of plantings but may also include walkways, patios, and other landscape features. The plan must include more than removing the tree for which the Type 2 permit is requested and planting required mitigation trees. The applicant did not submit a landscaping plan. On the application, the applicant described the reason for removal as fall risk to property, which is not a reason for removal under Type 2 criteria. Criterion 1 is not met. Criterion 2 addresses impacts to erosion control, flow of surface water, and protection of adjacent trees. Based on the evidence provided in the application and the city's contract arborist assessment, the requested tree removal will not result in significant negative impacts on erosion control, flow of surface waters, or protection of adjacent trees or existing windbreaks. Criterion 2 is met. Criterion 3 addresses tree removal impacts on the character or aesthetics of the neighborhood. This standard is met if the removal of the trees does not involve A, a significant tree, which is defined by Lake Oswego Code, B, alterations to distinctive features or continuity of the neighborhood skyline, C, trees serving as a visual screen between different neighborhood zonings, D, a street tree, or E, removal of 50% or more of a stand of trees. A significant tree is defined by Lake Oswego Code as a healthy, non-invasive tree over 15 inches in diameter that is considered significant to the neighborhood due to size, species, or distinctive character, or the only remaining tree on the property. Both trees were found to be in generally good health, are non-invasive Oregon white oaks, and listed above 15 inches in diameter. The city's contract arborist described the trees as of average size relative to other trees in the neighborhood and not unique to the neighborhood. Being of average size to the neighborhood and not unique species, staff finds that neither of the trees individually provide distinctive character to the neighborhood. The trees are also not the last remaining trees on the property. This subcriterion is met. Criterion 3B. This subcriterion requires the applicant to show that the tree removal will have no significant negative impact on the character or aesthetics of the neighborhood by altering distinctive features or continuity of the neighborhood skyline. The applicant stated on the application that no change to the distinctive features or neighborhood skyline would result from the tree removal. Staff observed that the trees are prominent from various viewpoints of the neighborhood as shown in this photo and in these photos. Staff found the proposed tree removal would alter the distinctive features or continuity of the neighborhood skyline as viewed from public streets and properties within 300 feet of the site. This subcriterion is not met. The remaining subcriterion were met, and I'll just go through those quickly. 3C, the property is residential and surrounded by similarly zoned residential properties, so the trees do not serve as a visual screen. 3D, the applicant has shown the trees are not located in the public right-of-way, so they are not considered street trees. And 3E, the two proposed tree removals are not located within a stand of trees, nor are they part of a continuous canopy of a stand. As based on subcriterion 3B, removal of the trees would alter the neighborhood skyline. The removal will require an exception to criterion 3. Criterion 3 is not applicable when a tree is likely to or will continue to cause damage to a permanent, viable existing structure or to infrastructure such as utilities or paved landscape features that cannot be remedied through reasonable tree maintenance or pruning. The applicant did answer one of the questions under the exceptions portion of the application, but stated that multiple other oaks have fallen in the cul-de-sac. The applicant did not submit an arborist analysis as to whether the trees are causing or are likely to cause damage to an existing structure or infrastructure, and if it were likely that they were to cause damage, why pruning would not address the risk of damage. Again, the applicant's statement were related to hazard risk potential and not type 2 criteria. Criterion 3 is not met. Staff finds that the applicant has not demonstrated that all of the approval criteria of Lake Oswego Code 55.02.080 have been met. Staff recommends denial of tree removal application 499-24-000308-tree. If the commission finds from the evidence presented at this public hearing that the criteria for type 2 tree removal are met, staff recommends submission of a revised mitigation plan as a condition of approval showing 2 native trees to be planted on site as required by code. Thank you. That is my presentation. I'm happy to answer questions if you have any.
I'm going to ask whether any of the commissioners have questions, and I have one that seems to be very fundamental. Ms. Sissel, would you describe more clearly for me what the process would be for applying to make this a hazard tree? What is the city's process and code?
So hazard trees can be approved a couple of different ways. If there is evidence submitted that there is cracking, I think the hazard criteria is a hazard tree that is likely to fall and injure persons or property as evidenced by cracking, splitting, leaning, or physical damage. So in conjunction with type 2s, even if it doesn't meet quite that hazard standard, if it's showing some of those signs, sometimes there aren't reasonable alternatives to the removal. And so that would meet the exceptions portion. Does that answer your question?
Yes, so the hazard tree would be addressed under the same criterion that are applied to type 2 assessments.
They're 2 different applications and 2 different permits.
Yes.
They applied as a type 2.
Right.
Yeah.
Okay.
If I could just follow up on that, it was my understanding, I think in reading the staff report, that the city arborist found the trees to be in good condition, and I'm not sure if I remember correctly that they didn't present a hazardous, any significant hazardness.
Yes, so our contract arborist does visit all type 2 properties to assess the trees. We use her expertise to evaluate the trees for condition and then and structure type, so health and structure. If she believes that the trees are a hazard while she assesses them on site, we can convert the type 2 to a hazard application. She did not see any signs that these trees were a hazard, that met hazard criteria. Yeah.
I have a question. This past winter, we all experienced a storm that was not precedent that we've had, in the last few years, but something that was fairly significant. I had 5 trees in my neighborhood right next door that were all healthy trees, would never have been classified as a hazard tree. All 5 trees went down. 2 of them landed on the adjacent home. 1 just missed a home. And it was kind of shocking because our code doesn't address that situation. Kind of black and white, but it doesn't address that situation. So during the period of time when we had all this storm going on, I know the city said, hey, if you've got some trees that you're concerned about, we're not going to have permits that are needed in advance. You know, you could follow up or whatever. So there was some consideration given due to that storm and that situation. And I believe in this situation, there was people in this neighborhood where these trees are that also had trees down. So how are we going to approach that type of thing?
Vice Chair O'Connor, I don't think this is the appropriate venue to be discussing future tree removal
Fine.
criteria, and I would limit your discussion and deliberations to the record in front of you. The applicants have applied for a type 2 tree removal. They have not applied for a hazard tree. So again, I just want to make sure that the commission is focusing on the type 2 tree removal.
Right. Okay. Thank you. It didn't sound like these trees would meet a hazard classification.
The applicants did not ever submit a hazard tree removal request.
But didn't the city go look at it?
The city's arborist was on site and did evaluate the trees and could do a cursory look at it. She did not see any obvious signs of hazard.
Right.
But an applicant can always hire a private arborist, a tree risk assessor qualified arborist, to do a deeper evaluation of the tree and then submit that information to the city, and we can then evaluate the hazard tree removal request. That was never submitted to the city. They have only issued, or they've only submitted for the type 2 tree removal. So.
Very well.
Any other questions? Well, we will now hear from the applicant, and after that, we do have some requests for time for people in the audience to comment. But let's hear from the applicant first. The applicant has 20 minutes to make a presentation.
And as you're getting set up in front of you for everybody here, there's a timer, and green means go, yellow means 30 seconds, red means stop.
It's so green is nothing is on so far. So
As soon as you start talking, I'll turn it to green.
okay. Well, thanks for having us. My name is Homoyan Hajarizadeh. I live at 14052 Edenberry Court. My wife Nazanin, we've lived there since 2001, so we've been there for a long time. So I think you wanted me to address primarily the denial reasons, so I'll go through them. I will come back to Commissioner Connor's point that there is no such permit type for what the type 2 is the closest application type that I could use. The staff kept telling me apply for type 1. It was very clear it would not meet type 1. And there's no, and I'll share the experience that we've had in the last 3 years. So type 2 is the closest permit type we could apply for. So I'm going to go sort of backwards a little bit, but one of the reasons that the application was denied was that it causes alteration to the distinct features or the continuity of the skyline. So in one of the submissions, I have a letter signed by 17 of our neighbors who walk across these two trees every day. Look through the windows, see it, and they all think that this is not the case. So they disagree with the arborist. And the photo, you see it. If you put those photos up, you'll see there are multiple trees, multiple oak trees that are in that neighborhood. These are two left. 16 trees within a stone's throw of these trees have fallen on homes. So this is the reason you see these, because all the other 16 trees are gone now. So the neighborhood does not think that these are prominent trees or prominent skyline. The other point is this, the city arborist who came by and looked at it said these are healthy trees. So I will go over multiple examples in this neighborhood, again, within 300 yards, where we've had arborists who come by, tell us the tree is healthy, and the next year the tree falls. So do you have the, I think it's F007, all those pictures of trees? Oh, so I'm gonna,
Staff doesn't have that ready for a presentation for you.
there-
We have the PowerPoint presentation that we'd be happy to flip in between slides, but we did not put the entire record available for your presentation tonight.
they were uploaded onto the city website. Is there a way to bring the application up?
No, I'm sorry.
Okay. It's gonna make it hard
If
for
I
me to
may
describe
interject,
things.
I would ask you to make your comment assuming, and I think this is correct, that the commissioners would all have reviewed the complete file. So if you have a point to make without a document that was in the file, the commissioners have probably all seen that.
Okay, so
You could also,
Exhibit
sorry,
A in
just
my,
to clarify, if you give an exhibit number, the commissioners do have the record in front of them, so
Okay.
they could look it up.
so Exhibit A in 2016, a healthy tree that was deemed to be safe fell in a fall storm. The tree was located across the street from these trees. And it fell actually during the day when landscapers were working. And there's a photo of that that's basically it's fallen right across onto the back of a pickup truck. In 2021, we wanted to have 3 trees in our backyard removed because we never felt safe sleeping during storms upstairs. Our kids were always downstairs. We just slept downstairs. We had an arborist. I paid, I think at that time it was $300 for an arborist to come in. They said, this is a healthy tree, trim it. So we did. There's Exhibit B1 where I paid somebody I think like $5,000 to come trim those trees. And those trees had been trimmed in 2002, 2006, 2010, 2015. And Exhibit B2 shows those trees fallen on my neighbor's house following winter. So here's an arborist says this is healthy. Next year, the trees were trimmed. Following year, it falls in my neighbor's house. 2022, Exhibit C. So having experienced my trees on his roof, the next year he wanted to remove a tree in the backyard. He asked for a Type 2 permit. The Type 2 permit was denied. Following February, the tree fell in his backyard. That's Exhibit C. It's a photo of him. So 2024, we all experienced the storm. The summer before that, my neighbor across the street wanted to have 2 trees removed. One of them was approved for Type 2. The other one was not. And then he had a third tree as well. We did not want to have that removed. Last January, the remaining 2 trees, one of them fell on the street, and one of them fell on my neighbor's roof. He's still out of his house. They're still fixing it. This is, 8 months later. So that's Exhibits D. That's the letter that Jay Kank sent you guys. Exhibit D2 is a tree that's fallen on our neighbor's roof. And D3 is the tree that fell in the middle of the street and took out all our utilities. So the entire cul-de-sac was without gas. We had gas fire underneath this true tree for 3 days. We were without gas, without electricity for a week. Nobody lived in their house for that week. So basically what I'm trying to show is a lived experience of arborists that come and say, tree is healthy, or we apply for a Type 2 that's denied, and then almost immediately, within a year or so, we get one of our storms, the tree's down. And we know history repeats itself, and storms are getting stronger and stronger and stronger. They're not going to get weaker. We're going to have bigger storms. The exhibits E1 and E2 are pictures of these particular trees that keep damaging my gutters and my roof because branches fall off of them. They're big trees. That's what trees do. And then when, the city arborist comes, they look at a tree. Nobody really looks at the roots of this tree. It's not a track arborist, but it's just basically somebody who cuts trees down, and he's done that for 20 years. Looked at these two trees right after the storm. They didn't have any leaves, so it's kind of hard to assess how the trees are in January. But, there he saw a lot of fungus on them, and so that's exhibit E3. He says this is not a safe tree. It's going to come down sooner or later. So if you do a Google map, like a street view right now, there are not that many trees around my house. But I found actually Street View from MapQuest, which is probably 10 years old. And so I printed those. And if you look around those things, I didn't put all the pictures in, but there's 16 trees that have fallen, basically within 200 yards of my house. They have either been removed by type 2 application, removed by type 1 application, or have fallen. These are really the only 2 oak trees left. And they're going to fall sooner or later. And the idea is we've been really lucky that nobody has gotten hurt. We really have been. This tree last year fell on the street, fell right next to a car. The one that fell in 2006, there were landscapers working in the yard when it fell, missed them. The other tree that fell on the roof, they were lucky again, it didn't go through the house. It could have easily gone through the house. The 3 trees of mine that fell, there were 2 other trees that held them, otherwise they would have taken out their bedroom, the master bedroom. And then the other point is that a similar type 2 application actually has been approved for the same type of a tree. So 2 years ago, my neighbor, and I think I put that as F. This is Dallas, yeah. I submitted that a little later, but I found it, again, a street view of their house. So these are the neighbors right next to me. So they had 3 trees of mine that fell on their roof. They had a tree in their backyard that fell in the back when the type 2 was denied. So last summer, they applied to have a tree in front of their house removed, pretty much like the size of my tree. They applied for a type 2, and it was approved. About the same distance from my house, had fallen branches just like mine. Wasn't leaning necessarily, but they were experiencing the same fears that we do. They had 2 small kids, they never slept upstairs in the storms. All the kids and everybody slept downstairs every time we have winter storms. So their type 2 was approved. So type 2s have been approved in our neighborhood for similar reasons. So as I started to say, the city's tree removal permit types are not really adequate to cover this type of a request. Type 2 is the closest to it, and it's been approved with the type 2 for similar reasons in the past. The city has approved it. Now they don't. I understand there's probably 1,000 applications this year because everybody's afraid trees are going to fall. Reasonable. So the city staff did ask me to change the type 2 to a type 1, But I did actually pay a track certified arborist, and he says, you know, I can't, you know, don't meet the strict criteria that the city has for a type 1. So if the city would change the criteria, maybe it'll meet type 1, but right now it doesn't. So what's left is type 2, there's no other type. So I think in summary, we think that the request is more than reasonable. It's really for the safety of ourselves and our neighbors. Storms are going to get worse, and history is going to repeat itself. And it's going to fall on my house or my neighbor's house or somebody who's walking in the street. So the other thing I want to do is my son who grew up in this house wrote a letter. I think I'm just going to, that was also submitted for your review. I just want to highlight a few things he said. So he's 26, so he grew up in this house. And he, you know, he's appreciated growing up in a place that meets the intersection of nature and residential living. But these trees that fell on our neighbor home when they were asleep, this is about our trees that fell on my neighbor's house. With children in-house was really scary, and then thankfully they were not injured. And I agree with this, that our cul-de-sac is genuinely very lucky that nobody was severely injured because of these trees that we've lost, especially this last storm and 3 years ago. And it's just sheer luck. I mean, if it had gone up, you know, 10 feet one way or the other, cars would have been gone, people would have died. And you all live, if not within a block of a tree fallen, I think within a neighborhood of trees fallen this last storm. And driving around and seeing the absolute destruction of our community because our city lacks the foresight to take preventative measures is deeply concerning and frustrating for him. And here we are. You have people that are earnestly requesting a tree removal, not to the vanity, not as a vanity project, but as a preventative measure for health and safety of their family and the families around them. It is frustrating for him and disheartening to live in a place that would deny a family from taking preventative measures for safety. You want to read your letter? So I will read the highlight of last of your letter. And another thing says, she still can't get around the sound of the fallen tree out of her head and will not be able to live with herself or ourselves if our two trees would damage, hurt, or take someone's life. So the fear is real. It's happened to us. Can you put up a picture of the map of the street that you showed?
Here?
Yep. So the star is our house. So we've lost 3 trees in that one. The one right next to you see, which is 5086, had a type 2 removal approved last summer in the front of their house, had 2 trees in the back that fell on their house, had 1 tree in the backyard that was denied a type 2 that fell. The house across from Hastings Court had 2 trees this last winter. One of them, for which a type 2 was denied, fell on the street. One, they didn't apply for a removal, fell on the neighbor's house. And then he had a type 2 approved last summer that was removed. Across the street from me, so across Edenberry Court, that's the one I showed from the beginning, the first picture of the fallen tree in 2006. Kitty across from me, 140-50-69, he removed 2 trees in his backyard during the storm because they were going to fall. 140-77 removed the tree in the front of his house right there during that storm, applied for a type 2 afterwards. 14068 just had a type 2 approved, removed, I think, a month ago. So, and then on the other side of me, 14044, I don't have pictures of his, but he lost 2 trees in his backyard within the last 4 or 5 years. And our neighbor on Kitty Cross on Hastings Court, 5083, they've been out of their house since January. So I counted 17 trees that we've lost in the last probably 15 years. You have any comments? You registered separately, yeah.
I feel nauseous, first of all, to be here.
Could you lower the microphone so we can pick that up?
Is that better?
Yes.
Okay. I felt nauseous coming here. I've never been to a hearing, to anything like this. We've loved our neighborhood. We've loved living in Lake Oswego, living in our house. And the trees were a selling point. We loved, when we were looking, we fell in love with the trees. Nobody wants to spend that much money to take trees down, but when you don't feel safe in your own home, it's not realistic to me. And all these years, every time we've had a storm, since our kids were little, I would advise for everybody to come and sleep downstairs. And in 21, when we lost the trees in the back, our boys were home. It was during pandemic, and they were home, and we were all downstairs when the thump happened, and the whole house shook. And I cannot get the sound out of my head. And when the tree across the street from our house fell, we were home that afternoon. And for some reason, I don't know, some people are more sensitive, and the sound of fallen tree stays in your head, and for some people, they might forget. I cannot get that out of my head. And we don't want to leave Lake Oswego. We want to stay in our house and retire in this area. And to me, it's unrealistic that we don't have permission to take those trees down for the safety of our neighborhood. That's it, that's all I wanted to say. I'm not as organized as my husband, I don't have paperwork, but that came from my heart, that's it.
From the heart is also very important to us.
Thank you, I appreciate it.
Commissioners, do you have any questions of the applicant?
The trees that your neighbors took down, I believe some of those were instances that we were given reports on why they were allowed to be taken down, because they were deemed not healthy or had split some, issues why they were allowed to be taken down. The reason they denied yours is because they're healthy trees. And I guess the second question I had was, you said you lost power because the trees came down, but your utilities are underground and your gas is underground. So we all lost power in that area from something that happened far away, not from the trees coming down in our neighborhoods.
The tree, there's actually a picture that I submitted showing the utility trucks going in. So the tree root was actually over the gas line and right next to the PGE box that goes to the entire neighborhood.
I see.
So when the tree came down, the root basically tore the gas line. So we had a gas leak, and we had fire actually underneath ground for 2 days. You could see smoke coming out. So actually, fire department came, closed our cul-de-sac, wouldn't let people go through the cul-de-sac. We had to go through our backyards to get to our homes.
Thank you.
And one of these trees, the gas line that comes to my house and the electricity that comes to my house, it's over the power, the power just to my house, but one of these trees is over those.
So Jay's house is 140.
70.
6-8.
140, yeah.
I can't see, if you see the red star right across in the Hastings Court, that tree came down onto the cul-de-sac on the top of the gas box. And so for the whole week, PGE map showed 8 homes without power in Westlake. And those 8 homes, we were part of that. We went to his dad's house in Beaverton for that week. And as far as like arborists saying that trees are healthy and they're not gonna fall, as my husband mentioned, we had the same thing happen in '21. In the summer, we paid, they came and they said, your trees are fine. We just trimmed them, they're great. And then they fell the following February.
Do you see the conundrum, though, if we were to say, yes, please go ahead and do this, we approve? That gives carte blanche for everybody to do the same thing, and we'll be clear-cutting Westlake.
I'm not for clear cutting at all, but
Yes,
if,
but you
if
see,
people,
you
if
set a
people are not
precedent.
feeling safe, like, have you ever had a fallen tree in your backyard? Have you ever experienced that, anything like that, or anybody
My whole
else?
neighborhood had 60 trees that came down.
Have you talked to any of those people who had to go through that?
I understand the trauma. I'm just saying from a perspective of good governance. Once you open Pandora's box, where do you stop it?
Mr. Chair, if I can be a little more directed on that topic.
Yes.
This commission is reviewing this application pursuant to 5502-085, request for public hearing on a type 2 tree removal permit. Subsection 3 says, following the close of the public testimony, the DRC shall determine, based upon the evidence and testimony in the record, whether or not the application complies with the criteria contained in 5502-080. That's the task to the commission, is determine whether the criteria is met. The findings, conclusions, and orders shall contain the DRC's reasons for approving with conditions, or denying the permit. What I hear is the applicant has acknowledged that some arborists have found them to be healthy trees and they have fallen over. Okay? They have fallen during a storm, et cetera. That is not criteria that has already been adopted. And I think to Commissioner O'Connor's question is, what do we do? This commission's challenge, we're limited to criteria. What they're asking for is a different code, different code standards. I think what they're asking for, to Commissioner Leake's part, is a code which would allow tree removal for any tree that is within its height from a structure or utilities. That's whatever. But that's not in the current code, and that's what this commission is tasked with on that. So I would ask the applicant and any person testifying in addition to that's the challenge that the commission has, is it must find that the criteria contained in 5502-080 is met, okay, before it can approve. Otherwise, I think you're asking for a code amendment, which would be to the council.
Well, I just want to make one comment, which is, we're not just asking for a clear cut. You know, the fact is that in this particular microclimate of this area, so many trees have fallen, and oaks, you know, need each other to protect it from the wind. And basically everything else around these two trees have fallen. And so they are dangerous trees, but they just don't meet the very strict track criteria that the track survey for arborists has to go through. And that's the issue here. And so it's really a safety issue. It's not clear cutting.
May I, any other questions? I have a question. At the beginning of this hearing, I asked Planner Sissel to describe the option for requesting an evaluation under type 2 for a hazard tree, and that was clearly stated by her to be something that was available to you. In the report she made, she reports that she did pass that information on to you, and that you had the opportunity to supplement or change your application to reference specifically the hazard tree removal and to engage a tree risk assessor that was qualified. And you apparently have not done that. And I'm wondering, why didn't you do that as a means of keeping your application within code?
I did do that, but the very strict criteria that the track certified arborist has, there's a 2-page assessment. This tree does not meet that very specific criteria.
Thank you very much. I think that's an important piece of information for us. Any other questions?
Yes. Of the trees that you're aware of in your neighborhood that fell to the ground, did they break off or did they uproot?
Almost all of them have uprooted. And that's the other thing, is the arborist cannot assess the health of the root of these trees. And it's amazing that such a huge tree has such shallow roots. And it's just because, we're in a clay area and we water everything. And so these trees don't have to have deep roots. So that's why I suspect this is the reason why the arborist really cannot truly assess the fall risk of these trees, because they're not just branches coming off, the whole tree is going down.
Right. So what I'm hearing you're saying is the arborist can only evaluate what he or she can see.
Yes.
And it's primarily with the structure of the tree above ground.
Any other questions from commissioners? We have 2 requests for a statement, but these requests came from the applicants. Am I correct that those, we have already heard from the applicants, and so that these 2 are not something that we should deal with at this point?
I'm sorry, what statements do we have?
Sorry, so I believe that the applicants registered to testify in support of their application, which was not necessary, thank you, but it wasn't necessary because they have testified. Kat, do we have anyone else that is signed up to testify, either for or against or neutral? Okay, so there is no additional public testimony.
Yeah. Okay. We're going to ask now that the commissioners discuss what we have heard from the applicant and from the planning department. Who has a comment?
I'll start. Well, first of all, I appreciate what you've gone through, and particularly the trauma that's occurred from that. Over the last few years, the 2 ice storms over the past 2 or 3 years, we've had, I believe, 3 trees on our property and numerous others on our neighbor's property fall. Thank goodness, not on our house, but on a number of our neighbors' homes with significant damage. So I certainly understand your feelings and where that's coming from. However, one of the special aspects, I think, of Lake Oswego when we moved here about 4 or 5 years ago was the consideration for trees, the idea that Lake Oswego we live in an urban forest. And I think to your son's point, even his letter, he mentioned about living in balance with nature and with the trees. And that's something that I think is really important to the core of this city. And that idea that, well, based on our city's policies, we're actually advocates for the trees, particularly in this case where there's no issues of any sickness or hazardness with the trees themselves. And yeah, they're not neither of them are sick, they're not failing. And unfortunately, as noted by the staff, these trees just don't meet the criteria for removal under the type 2. And I certainly agree with that and believe that this application should be denied.
Other comments?
Yes. I think we have all heard and listened and probably agreed that there is no way for the arborist to evaluate the root structure, the subsoil, whether it's clay or rock or anything else. So that is something that there is a risk there, because he or she can only evaluate the tree structure above the ground. I, like many of us here in Lake Oswego, really do appreciate the trees that we have, and it makes it a beautiful. But the people that are appreciating it are also appreciating health and safety. I feel that the amount of trees that have fallen in that neighborhood indicate a subsoil structure and potentially a tree structure in the roots that are not what we would expect with most trees. And it's been demonstrated time after time. This isn't circumstantial evidence, this is real, solid evidence that those trees are subject to getting blown over, not breaking because they're rotten, getting blown over. And these people here are people that are looking out for the life, safety, and health of not only their own family and guests, but their neighbors as well. I think that they have the right to ask for tree removal. I don't think we are in a great position with our code to evaluate below the ground. And so we're at risk of having these types of situations occur in the future. I support the trees being removed.
Commissioner Leek?
I've walked this neighborhood for way too many decades. And our neighborhood sustained many, tens and tens and tens of trees that came down. What I also know as a realtor and selling homes in Westlake is you have a very high water table. And that's what lends itself to the instability of these trees. My problem with allowing you to take these trees down is it opens up all of Westlake for everyone to say, well, I've got the same hazard. I want these taken down. And my heart just says the code doesn't allow, my mind says the code doesn't allow that. And my heart says, I know what will happen. There will be more dogwood trees in Westlake than native oaks. So for those reasons, I would decline to allow this permit to go through.
Any other comments? Well, I'd like to make a comment and then ask my colleagues to make a motion. I want to remind us all, we are charged with implementing a code. We are not given any prerogative to change the code. And in this case, the code, from my point of view, is crystal clear, and this does not qualify for approval. Moreover, I do disagree with the comments that this has not been assessed adequately. I'm not an expert on what a tree risk assessment qualification expert does, although I am a risk assessment expert. But I assume that that professional in his evaluation of the trees would have been aware of the high groundwater, would have been aware of the history of soils in that area not supporting deep roots. And so if that piece of information was provided and concluded that these trees are not a risk, that for me is also another reason for me to feel that there is no justification for approving this application. And I would like to support, and I will support, the recommendation from staff to deny this. But I come back, our responsibility is the code. And I don't think we have any choice other than that. So can I have a motion from someone one way or the other?
Can I just say this? I think there's a middle ground, and the middle ground is that I don't know if the city or the arborists that have looked at these trees have the amount of information that we have received. They have not?
They simply come, look at a tree from a street. They have no history of the neighborhood.
Okay.
They don't
No,
know
just
any
a
of
minute,
Testimony.
just a minute, just a minute.
So,
This is
Commission
discussion.
deliberation rather than testimony.
okay, so how about, rather than approving or not approving, just having a second go to see if these trees can be reevaluated and potentially be evaluated as hazard trees?
By code, the code allows for a reapplication.
Yes.
And that would be
That would be a
appropriate if we were
separate-
to deny it.
That would be a separate application. Yeah. That's-
Well, I realize that we would need to deny and you'd need to reapply, but I didn't think that that was necessarily clear.
Commissioner Dews, I think you were about ready to
Yeah,
make
I
a
was
motion.
going to make a motion that we deny the removal of the 2 trees in tree removal application 499-24-000308-3.
Yeah, and I'd like to amend that. I think we should be specific in supporting the criteria that were not met in the staff report, which would be for criterion number 1, 55.02.0801, and for the other, it would be 55, too many notes here. Yeah, same number, 3B.
I appreciate that, yeah.
I second.
Would you call the roll, please?
Sangre,
I vote to deny.
O'Connor,
Deny.
To be
Dews?
clear, Mr. O'Connor, because of your statement, the motion is to deny the application. You're voting
Right.
I
in
am
favor of the
voting
motion.
aye on the motion.
Okay.
O'Connor, I have you as denying.
I was denying.
Okay. John Dews,
Aye.
Bates,
Also denied.
Leek,
Aye.
Mino,
Aye.
Lindstrom,
Aye.
7-0.
All right, this is a tentative decision by the commission with written findings to be brought back on August the 19th at 7 PM.
For now, yes.
It's good to know that you guys appreciate the trees more than the human lives. Thank you.
Okay, we have a second hearing. This pertains to what's our reference number? It's not on here. Let me see if I got it on my other one. Yeah. It's 23-0045. And it is a request for the two parcel approval on Goodell Road. And yeah, I think that that's all. Yeah, it's a petition for flag lot and minor variances on the front and rear setbacks at 2112 Goodell Court.
Mr. Chair, would you like me to do the hearing procedure? Are we at
Yes.
that point? This will be slightly different than the previous one. The public hearing process, again, is a presentation by staff, followed by testimony by the applicant up to 20 minutes, then testimony by parties in support of the application, followed by testimony by parties opposed to the application, and finally those neither for nor against. Individuals allowed up to 5 minutes. Any person in attendance may cede his or her time to another person, except to the applicant, but in no case shall any person's testimony be increased to greater than 10 minutes. Recognized neighborhood association, homeowner associations, government or government agencies, or other incorporated public interest organizations will be allowed up to 10 minutes. Those time limits do not include time spent responding to questions from the commission. Testimony by attorneys, representatives, and witnesses on behalf of which part of the presentation by a person shall be counted within that person's time limit. It is assumed the person is testifying on their own behalf unless they expressly identify the recognized neighborhood association, homeowner association, government or government agency, or other incorporated public interest organization they are representing. After testimony in favor, opposed, and neither for nor against, and the applicant's rebuttal, up to 5 minutes. Following that would be commission deliberation, including a statement to the applicant by the commission of proposed conditions of approval different than contained in the staff report, and the applicant's response to the commission's conditions of approval proposed following the commission deliberation. As stated in the public notice, the deadline for submission of written materials was noon today. No written materials may be submitted to the commission tonight. Any person may request an opportunity to present additional evidence by requesting a continuation of the public hearing. This land use request is based upon the applicable criteria and standards. Staff report lists the criteria that staff identified was applicable to the request. It was available online and from the planning department. Testimony and evidence must be directed towards the applicable criteria. Please identify to the commission the criteria standards you're addressing to the commission so it may consider your testimony in relation to those criteria standards. If you do not identify the criteria standards you're addressing, the commission is not obliged to guess which standards or criteria you're testifying about and may not consider your testimony in its decision. Failure to raise an issue accompanied by statements or evidence sufficient to afford this commission and the opportunity to respond to the issue precludes raising the issue to the City Council and the Oregon Land Use Board of Appeals based on that issue. The failure of the applicant to raise any constitutional or other issues relating to proposed conditions of approval with specificity to allow the commission to respond to the issue precludes an action for damages in circuit court. A potential conflict of interest is declared on behalf of each of the DRC members to the extent of their business or employment, which each will identify. Unless declared otherwise, the respective DRC member does not have a known present or anticipated future business relationship with the project or the applicant. It's possible that a future business relationship could arise in the initiation, design, construction, or maintenance of the project through either the employment or business of the DRC member personally, or through a relative as defined in ORS 244-020. At this point, I would ask the commission members to please declare if you have any ex parte contacts, including a site visit, if you have any bias on the application, any financial conflicts of interest, and please state your business or employment. Commissioner Mino.
My name's Yuko Mino. I'm an architect. I have not visited the site. I do not know the parties involved, nor have I had any ex parte communication. I do not have a financial interest or a conflict of interest in this case. I do not have a bias.
I'm John Dews. I am a retired architect. I have not visited the site. I have not had any ex parte contacts. I have no bias, nor do I have any financial conflict of interest.
I'm Helen Leek. I'm a realtor. I know where the site is. I have not visited it. I've had no ex parte communication. I do not know the parties involved. I do not have a financial interest nor a conflict of interest in the case, and I have no bias.
I'm Dwight Sangre. I'm a retired civil engineer. I'm familiar with the site. I have not visited the site. I have not had any ex parte communication regarding this project. I have no financial or professional interest, nor do I expect to have such, and I consider that I have no bias.
I am Russ O'Connor. I'm a retired senior project manager. Have no ex parte contact. I'm aware of the site. There's a Street of Dreams home there. I have no bias, and I have no financial conflict.
My name is Larry Lindstrom. I'm a construction executive. I have not visited the site. I have not had any ex parte communication. I do not know the parties involved. I do not have financial interest or conflict of interest in this case, and I do not have any bias.
My name is Kristen Bates. I'm an attorney. I don't have any financial interest. I don't have a conflict of interest. I know where the site is, but I have not visited it. I have not had any ex parte contact with the parties, and I do not have a bias.
Thank you. Is there any challenge to Commission's right to consider the application? Hearing none, Associate Planner Courtney Sims with the staff report, please.
Good evening, Commissioners. My name is Courtney Sims. I'm an Associate Planner with the city.
Your mic on?
Oh, no. Can you hear me now? Light's green. Can everyone hear me?
Yep.
Yes.
Okay. Good evening, Commissioners. My name is Courtney Sims. I'm an Associate Planner with the city. We'll be discussing Land Use Case LU 2345, a two-parcel partition with two minor variances to setbacks at 2112 Goodall Court and tree removal associated with the required improvements. I'll start by reading into the record exhibits received prior to the noon deadline today, but after the notice of decision on June 18th, exhibits E13 and G508. A bit of background, the site is located at the intersection of Goodall Road, a neighborhood collector, and Goodall Court, a private access lane within the Forest Highlands neighborhood. The site is comprised of two tax lots, but for development purposes is currently only one legal lot of record. The property is surrounded by a mixture of incorporated and unincorporated properties and is zoned R15. The applicant is proposing to divide the site into two parcels, aligning with the current tax lot configuration. The existing dwellings on what will be parcel 1 is proposed to remain, and parcel 1 will become a flag lot by definition. Goodall Court, a private access lane, was created as part of a subdivision wall in Clackamas County, and many of the properties on it are still unincorporated except the subject site and properties directly to the north. Within the city code, private access lanes may only serve up to 3 lots. Since Goodall Court currently serves 8 lots, parcel 2 will be required to have access on Goodall Road. Both parcels were found to comply with the R15 zone dimensional standards, including flag lot standards for parcel 1 with the existing dwelling. The dwelling on parcel 1 was reviewed to ensure that the new lot size and configuration would not create anything out of compliance with the code. As a condition of approval, a portion of the deck that encroaches into the new 10-foot side yard setback must be removed, circled in red here. For parcel 2, the non-flag lot, the applicant also applied for minor variances to the front and rear setbacks. The applicant is requesting a 15% or 4.5-foot reduction to the rear setback and a 10% or 2.5-foot reduction to the front yard setback. As detailed in the staff report, staff found that the 2 minor variances meet the criteria. Because of this, both parcels were found to either comply with the applicable zone and or flag lot standards or can comply as conditioned. Now I'll provide some background for the next part of the application, specifically the required public improvements and the tree removal associated with those improvements. This was the subject of all but one of the comments, specifically whether public improvements are required and if alternatives that prevent tree removal are possible. The utilities standards from Chapter 50 apply to residential development that increases density and states that public utilities, including pathways and stormwater swales, shall be installed. The applicable street standards for sites within the Forest Highlands neighborhood are the rural streets requirements. These include 6-foot wide pathways and 8-foot wide stormwater swales, shown in the cross-section on the left. Per the city's Transportation System Plan, or TSP, neighborhood collectors must have pathways or sidewalks on both sides of the road. They are able to be conditioned when there's development that increases density, such as a minor partition like this. Per Chapter 50, pathways and other public improvements shall be designed on the site's frontage that abuts the street. If right-of-way is insufficient, additional right-of-way must be dedicated to allow for these frontage improvements. The applicant is dedicating about 6 feet of right-of-way along the parcel 2 frontage on Goodall Road. This slide goes over what, if any, flexibility there is for requiring frontage improvements. Chapter 50 street standards only allow improvements to be reduced or eliminated when existing infrastructure meets the standard, when it's not the appropriate time to construct the utilities, at which point it is deferred, or when the infrastructure required exceeds the rough proportionality legally permissible, an assertion that only the applicant can make. The bottom half of this slide discusses when the sidewalk requirement may be waived by the city engineer, per Chapter 42. None of these scenarios are applicable in this instance. The street is not a low-volume street. There are existing sidewalks, including one directly north across Goodall Court, and the surrounding area has improvements that were conditioned as part of a previous development application on both sides of Goodall Road. As I mentioned, these same improvements have been required in previous development applications on the west side of Goodall Road, including the property immediately to the north of the site and further south. The photo on the right is the existing pathway directly north of the site, which will connect to the new pathway. The map on the left shows existing and currently conditioned pathway improvements based on the same standard for recent developments. In summary, unless the frontage improvement requirements are already met, deferred to a later date, or more than we can legally require based on the applicant's assertion, the improvements are required on this site. Now I'm going to discuss the flexibility that the city has in the design of the public improvements. Chapter 50 street standards implement the engineering department's urbanizing rural fringe and transition neighborhoods policy to sites within the Forest Highlands neighborhood. I'll call it the rural street requirements for brevity. These design standards for rural neighborhoods are shown in both the cross-section on the left and further clarified and augmented in the rural street requirements guidelines, Exhibit F9. Rural street standards require wider, shallower stormwater swales and wide asphaltic concrete pathways, and the guide provides clarity to the design flexibility. The guide discusses the flexibility as follows. For the 8-foot wide shallow stormwater swales, the guide states that culverts can be allowed when right-of-way or grades do not permit swales. The applicant is currently proposing to use the culvert under the new driveway serving parcel 2. Extending the culvert to route around a nearby large oak tree was considered as an alternative to removal. For the 6-foot wide asphaltic concrete separated pathways, the guide states that when pathways must meander to avoid a tree, the pathways shall meander behind the tree rather than hug the edge of the roadway, and gives the city authority to require an easement on private property for the meandering pathway if there is insufficient right-of-way. So to summarize, the rural street requirements, public improvements are required per Chapter 50 and 42 of our code, as well as the TSP. The options for design flexibility in the rural street policy guidelines allow for a culvert to be used instead of a swale if necessary, and the pathway is allowed to meander, but only behind a tree away from a roadway. 11 trees were requested for removal for private utilities or public improvements. This includes trees that aren't directly on top of the pathway or swale, but that the applicant's arborist identified as being too impacted by the proposed construction to survive. 2 of these trees, marked in blue, are not the subject of Type 2 criteria, and 2 require exceptions analysis, which I'll discuss next. The Type 2 tree removal criteria are shown on this slide, and I'm sure you're very familiar with them after the last hearing. All 9 trees meet the criteria 1, 2, 4, and 5. So I'll focus on criterion 3. Removal will not have a significant impact on the character or aesthetics of the neighborhood. This criterion is not met when a tree is significant, distinctive to the neighborhood skyline, creates a visual screen between dissimilar zones, is a street tree, or is more than 50% of a stand of trees. Criterion 3 was not met for trees 23 and 29, so an exceptions analysis to the standard is required. Tree number 23 is a street tree within the current public right-of-way. Tree number 29, a 38-inch Oregon white oak, was found to be significant due to its large stature. Because of this, both of the trees must be reviewed for the exceptions to criterion 3. To meet the exception, the applicant must show that there are no reasonable alternatives to removal as permitted in the zone. The applicants must meet other standards as well. So alternatives that require a major variance or do not meet the development standards, including public improvement requirements, are not considered. I'll start with tree 23, an 18-inch Oregon ash. This tree is within the public right-of-way and next to an existing stormwater ditch abutting the property to the south. The applicant is required to connect a stormwater outfall to the ditch as part of the engineering requirements for stormwater management along the street. No alternatives are possible as stormwater management must be provided. There are no alternative locations to connect the on-site stormwater to the existing stormwater drainage system along the street, as that drainage system is already in place. Staff finds that there are no reasonable alternatives to removal and that the exception for criterion 3 is met. Regarding tree number 29, a 38-inch Oregon white oak, this tree was determined to be significant due to its large stature, as stated by the applicant and confirmed by staff. The applicant's arborist provided a thorough analysis to alternatives to removal. The tree is situated right where the driveway, swale, and pathway are required. As a reminder, the pathway and swale are required and design alternatives are limited. Looking at each of those elements, for the driveway cannot move further to the north towards Goodall Court as it would not meet access spacing requirements, as well as require the removal of a different tree, another tree number 32, there we go. Another Oregon white oak that's very large. Moving the driveway further south would not meet safe site distance requirements. As I mentioned earlier, Goodall Court is a private access lane that is already serving more lots than the code would allow, so access cannot be shifted to the private access lane. For the stormwater swale, eliminating the stormwater swale completely is not allowed, as the rural street requirements require an 8-foot wide, shallow swale. Converting to a pipe and culvert system just near tree 29 would still require grading and impacts to the critical root zone, which, when combined with the construction of the pathway and driveway, would still not be an alternative that prevents removal. Additionally, the pathway will not be able to meander towards the street just because the swale is converted to a culvert, as discussed previously, that the pathway must meander behind the tree. Meandering the pathway behind the tree was identified as still impacting the tree's critical root zone, as well as having more impact on the other Oregon white oak, tree number 32. This design would also require meandering a path up to 30 feet away from the pavement, which the applicant deemed an inappropriate encroachment of the public access easement onto their property. Based on the findings from the applicant's arborist and applying the city's engineering and development code, staff concurs that there are no alternatives that meet the code and that prevent the removal of trees 23 and 29, and that the exceptions to criterion 3 are met. Staff recommends approval with conditions as discussed in the staff report. I will be available for questions. We have Assistant City Engineer Will Farley here as well.
Commissioners, do you have any questions?
I have a question. Yes. What are the requirements on Goodall Road for pathway or sidewalk? Is it both sides of the street, one side of the street? What is it?
So Goodall Road is identified as a neighborhood collector in our transportation system plan, which requires a 6-foot pathway on both sides of the street with stormwater swells as well on both sides of the street.
So if there are existing properties that aren't under development or change, how are those pathways or sidewalks addressed?
So properties under the city's jurisdiction or within the city can have pathways constructed as part of a capital improvement project.
Okay. Which I believe has been done in other areas in the city recently for school access.
Correct.
Okay.
How does that apply to lots in the county?
So the county becomes a little bit more difficult because you can get a capital improvement project to build the project, but you would likely have to purchase or acquire the property if it's within the county.
Thank you. Other questions?
Do you have any idea what the linear footage of sidewalks are on the two sides of the street existing?
I have how much is needed to complete from my work with the Transportation Advisory Board.
Okay.
On the east side of the street, which has a capital improvement project identified to connect Noss Road to Country Club, it is missing about 670 feet with 310 feet of gravel, or 310 of gravel needing to be done with that, so about 980 feet altogether. On the west side, which we're applying from Noss Road to Hazel, which is the back access to the high school, we're missing about 900 feet if this project frontage is included. So this figure kind of shows north of Hazel here.
I've got a question. I was wondering what is, I believe it's only 8 houses maximum that could be accessed from the private road. That's the reason why that the driveway is going to be accessed through Goodall Road.
So the access road is non-conforming to our current access lane standards. It serves 8 lots. Oh, it's not green again.
No.
Can
Move
you
it
hear me
closer.
now? So the access lane standards maximum number of lots served by a private access lane are 3 lots, 2 of which may be flag lots. The access lane was constructed well in the county, so it's what we consider non-conforming. Increasing the non-conformity is not allowed without a major variance. In this instance, that would not be, that's not what's being applied for.
Thank you.
Any other comments? Okay, let's hear from the applicant, please.
For the record, my name is Bruce Goldson. I'm the applicant's representative. I reside in Lake Oswego, P.O. Box 1345, 97035. We have been at this process for 2 years plus, I believe. We went to a pre-application meeting. We got the instructions from the city planning and the outline of what we had to do on Goodall Road. We subsequently had meetings, individual meetings with planning and engineering to see if there were any alternatives that we could to save the trees. And we discovered there wasn't any criteria that we could apply that would mitigate or save the trees. we had we agree with planning staff that this is approved and we meet the code. We had an extensive arborist report, and I don't think, Courtney, is this in the file? I have a drawing in the file there that shows the actual location of the 30-inch oak, and hopefully you have this one, and the relationship to the path, the 6-foot pathway. And in this case, the pathway touches the tree, followed by the swale, the 8-foot swale, and then the 3-foot gravel shoulder adjacent to the road. So there's no possible way that we can save that particular tree by either going around it, even by reducing the width of the pathway, putting the swale in a pipe doesn't help anything because you're still cutting the roots off. So we do not feel that there's an alternative to saving the trees in this particular area. Plus, it's got to be, the entire site's got to be graded, and the grading to accommodate the pathway and to accommodate the swale make it a requirement that those trees along the frontage on Goodall Road will have to be removed. Location of the new driveway is a stipulation of site distance and driveway standards as far as separations from other driveways, and currently it matches a driveway on the other side of the street. And so that was the reason that it was placed where it's at. We're in complete agreement with staff. We don't like the result, but we don't see that to meet the code, we can do anything different. That's our basic position. And if the commission finds there's other ways we can address this stuff, we'd be open to that, but I don't believe there are. If there's any questions, I'm willing to answer them.
Thank you very much. Any questions?
Are mitigation trees required
Yes.
for the 10 trees that are being removed?
Yes.
Yeah. I think that's described in the staff report.
Okay.
No other questions? Thank you very much.
Thank you.
I have a note that there is one request for opportunity to offer an opinion in opposition. Mark Pullman.
Also, the FHNA Forest Islands Neighborhood Association is in appeal also. We're in appeal as well.
I didn't hear the discussion about there may be another request in addition to Mark Pullman.
My name's Mark Pullman.
Yes, Mark.
The Forest Highland Neighborhood Association lodged the appeal, and we have the Forest Neighborhood Association here to speak, and also I'm speaking as a citizen.
So you will both be speaking. The neighborhood association will have 10 minutes, you will have 5.
That is correct.
And who would like to go first? Okay. Please
Sorry for the
give us your
confusion.
name.
My name is Bill Jarish. I'm in the Forest Highlands Neighborhood Association, the board. And I did have a slide presentation. Unfortunately, got to the wrong email, but I'm going to talk through it. So the Neighborhood Association Board, basically the goal is for us is to preserve trees while improving pedestrian access. So it's this area in particular along Goodall. We recognize all the trees that are being taken down are considered healthy trees. In our neighborhood, the comments had 8 opposing, 0 neither supporting nor opposing. All supported saving trees, particularly number 29 that you've already gone over, is very important to the neighborhood character. It's a very large white oak, and most of those comments like that particular oak. Also, the activity on this, and this is the reason we appealed, was heard from the developer representative, has made several requests to save the type 2 trees. We also had a neighborhood meeting discussion where there was interest, and also in the pre-application conference. Now, our neighborhood, FHNA, has the lowest total tree canopy change. It's only gone up 1%. All other neighborhoods have increased their tree canopy, and that's per the state of the urban forest on December 22nd, if you want to take a look at that. So basically, we've lost a lot of trees to development, so our tree canopy is not growing. I did mention all the trees are healthy, and all the trees are being removed from the road frontage to accommodate for utilities and the pathway and possibly even the driveway. Okay, so you've seen the current street cross-section is the rural neighborhood collector street cross-section. What we found is that that particular design is often in this case, especially to the properties to the south, where they cross county lines. It's not really going to necessarily, unless they buy a lot of county property. And in our neighborhood, we had the Noss Road pathway, which is a pathway, a TSP design pathway from this road, Goodall, all the way to Lower Boones Ferry. I don't have a map. And what was done in that project in order to cross, so we had several pathways there that were similar to this one, the neighborhood collector out of the TSP. But then we had several that crossed county property. And what the city did, they did a fantastic job, is they designed a pathway that was approximately, I believe, about 4 foot wide instead of 6. And they were able to go around utility poles, trees. They didn't have to acquire any property. I think one tree was taken out on that project. So that's the kind of design that we would like to see considered for this project in order to save those trees. And what they did there was they used basically raised paths with curbs and now plant buffers. And it really required limited property frontage. The issue that we've had, because this is development driven, is that the properties in particular to the south, they said they're in the county, and I know the city wants to put paths on both sides of that collector. It's also right near the high school. So there's been, on the Transportation System Board, there's been a lot of projects related to safe routes to school. So the thing is that this design is going to basically go in, there's like, what, 8-foot swale plus the 6-foot sidewalk. But then below, if they want to extend it, it's going to have to come all the way out back. Currently, the design is also to come back out into the street, the exits into the street. And as you walk south on there, on these county properties, on Goodall, someone will basically have to walk on the street. So the thing we would really like to do is to put in a more narrow pathway similar to the Noss Road pathway to eventually connect with those county properties before they're actually developed. Because in the case of the Noss Road pathway, where they crossed county property, they didn't need to acquire any land. It was done simply by design. there's usually limited frontage on those county properties compared to the city. And they were able to basically put curbs in and put in a lot of underground, basically drainage. It was considered a large project for the drainage for that project. Another issue is avoiding the demolition of the current pathway for future connections. So in the case of Noss Road pathway, where you have this type of design, the rural road connector, where if you want to make it contiguous, what happened in the Noss Road pathway is several of these were put in due to development projects. Eventually, the Noss Road pathway was planned, and they had to basically rip up all the asphalt to connect them. And this design in particular, it's not connected really to anything except the street. So if you walk south, you have to make a left-hand turn, you're out into the street. If you have to continue to go down Goodall Road, there's basically swales and a lot of vegetation, so you'll have to walk out in the street. Safer way is to go on the other side, on the east side of that road. I think I mentioned that. And the reason, like, we're requesting an alternative is because in the TSP and also in the city code, the city engineer can alter the design. And that's most likely why the adjacent planned pathway, the Noss Road pathway over on Noss Road, which is like, it's basically where Goodall comes into Noss, where that was done. So it was altered and it got, there were about two to three presentations and input from the neighbors was done. So we just feel like the same thing could happen on this particular project, where they could try to save trees by making it more narrow and use instead of the standard TSP design, put the drainage under the ground like they did in Noss Road pathway. It's just that there's been a precedence for this type of thing in order to basically connect it to the properties to the south, which are two county properties. And that's kind of the goal, is to make it contiguous all the way down to Hazel Road, which actually goes up to the high school. So students can walk down it. Right now, after this is done, a student walking south will walk south, and it's actually in the staff report, the design. They'll have to walk back out into the street. And then there's no way that you have to kind of jump into, there's different small little swales. You have to jump into a swale or jump into vegetation. So there's no safe route heading south, but we would like those eventually be constructed. I don't know if typically what happens is like this, it's a development project, but if the city wants to, they'll have to do some kind of design with the limited frontage, or like the city engineer said, they'll have to purchase it. But that was not done in a similar situation where cross-county property. I think that's really all that I want to say about this particular project, is that there's a request to alter the design due to the prevailing conditions, and the desire really to save those trees. So this is not the standard, design I'm suggesting, and I don't know if there's a way around that. But if you go just by the code, what has been done has to be done per code. Any questions?
Thank you. Commissioners, any questions? Yes.
It may not be a question for you per se, but
sure.
Can the design be changed?
So for this one, we would fall to the TSP standards of having this pathway in the swell. Noss Road that was mentioned before was an identified capital improvement project where we were able to vary it with capital funds to meander it through what properties we didn't own for the best use of the city's dollars. This one is driven by development and intensification of the site. We have exacting right-of-way to construct the necessary improvements on this property.
And that's black and white.
That's per the code.
If I can slightly elaborate.
Yep.
Yeah, the reason why that is, the differences,
I get that the city paid for Noss Road.
The city paid for the Noss Road and has some flexibility. As this commission is aware, when we are looking at development application for housing, our standards must be clear and objective. The utility standard was rewritten in order to have clear and objective standards. The applicant has not asked for any variance to those standards, which would be a discretionary process. So the clear and objective standards are what drives this particular position.
Any other questions? Thank you very much. Mr. Pullman.
I was wondering if you could put up Exhibit E13. It just passed by here a moment ago.
E13.
That would really help my, yes.
Okay.
Thank you so much.
Yeah.
Let's see. I can keep my time. My name's Mark Pullman. I live in Forest Highland on Toma Road. I'm also on the Forest Highland Neighborhood Association Board. However, I would like to speak, I put in a comment, and I would like to speak as an individual, a citizen of Lake Oswego. I would like to suggest an alternative to what we're talking about. TSP asks for sidewalks on both sides of the street. However, if you take a look at the west side of the street, you'll notice that there are very large gaps on the west side of the street that have not been built yet. In fact, there are only two small sidewalks, one right above the proposed sidewalk, and one down really close right above Hazel. The rest of the area is bioswale and ivy, and that's all you can walk in. And so therefore you're walking on the street. If you take a look at the east side of the street has two properties. If we were to move the west side sidewalk to the east side sidewalk in the same area as the property is proposed now. But on the east side would be 13, and this one is 13340. If we put that sidewalk that is proposed to be on the west side of the street on the east side of the street, we would cover the distance from 2 blocks above Nouse Road all the way down to Hazel after the Street of Dreams 2 has completed their walkway, and they've taken a whole bunch of trees out to complete their walkway. Once they complete their walkway, there would be only 2 properties that we would have to bridge to get a walkway 2 blocks above Nouse all the way to Hazel. And that would be 13346 and 13348. Of course, all 3 of those properties are county properties, but in the front of those properties are large, very large parking strips that don't have any trees at all in them. You'd have to take down one small tree in the 13340 to make that sidewalk all the way down to 13346. And then the city would just have to pay for 2 properties, and they would have a sidewalk all the way up and down, rather than building a sidewalk on the west side of the street that dumps the kids out onto the street, or requiring them to cross the street onto the east side. There is a parking strip that they can walk on to get down to 13558 and then complete their walk down past the Street of Dreams 2. So I've been here for 13 years. There have been just these 2 little pieces of sidewalk built on the west side. I don't see any indication that the city, number one, is going to invest the money to put the sidewalk in on the west-hand side. So it is safer to have one contiguous sidewalk going down with a pedestrian crossing at Hazel to allow the kids to walk up to the high school. Hazel has a sidewalk. So it would be a very safe thing to do. And I really think it would be a safer way to go. I covered everything here. According to the Lake Oswego codes, the city manager can order a change in the LU to attain overall goals of the city. The goals of the TSP is to build a sidewalk, a contiguous sidewalk, to get the kids from Nouse to the high school safely. To do that, I think the best way to do it is to ask the developer, and they've been open to this, ask the developer to build the sidewalk on the east side of the street. That it's logical, it makes sense, it's cheaper for the city, and I don't see why we don't do it. Thank you very much. Oh, any questions?
Questions?
So you said the developer has agreed to this?
We have been in discussions with the developer ever since their first, and they were open to doing this, yeah.
Do you have any idea of building it on the east side if the property owner there would be amenable to it?
There's a large parking strip, and on that side, it is a county property. I have not spoken to the owner of the property, and the city owns the street, so it must have some right-of-way there. I don't know how wide that right-of-way is, but there would be some right-of-way there.
Commissioner Leek? No?
I just think this is a really smart solution. Does engineering and planning have any thoughts on this?
While Will is setting up his mic, I just want to clarify that those properties are not a part of this land use application, and there is apparently insufficient right-of-way to obtain the correct design as shown in the rural fringe cross-section. So that would require taking that property from those property owners that are currently in the county. And again, they are not a part of this application.
Ms. Heste is correct. There is only about 13 feet between the edge of the roadway and the property line on that east side, so we could not accommodate the 8-foot swell, 6-foot pathway, 3-foot shoulder, and the buffers between the pathway, so that we don't have sufficient space on that side. Additionally, we have a capital improvement project identified in the transportation system plan for that east side that we can use city dollars to construct the pathway connections on the east side as it's funded. So.
May I ask when that's going to happen?
Transportation Advisory Board has put it in as a priority as of 2019. They are currently deliberating on readdressing it to the City Council for funding for this next biennium.
So it's been 5 years, and you're hoping it might be 7.
We're hoping it will get funding, at least parts of it, to complete a connection on the east side.
Because
Again, I want to point out that the TSP and capital projects are not a part of this land use application, so.
Right. Can I ask engineering a question? If sidewalks were constructed on the east side, does that preclude the requirement that there be sidewalks on both sides of the road? You
No.
still have that requirement to deal with.
The TSP requires sidewalks and swells on both sides of the road.
Thank you. Thank you, Mr. Pullman. No other questions? All right, deliberation among ourselves.
Mr. Chair, the applicant has an opportunity for rebuttal for 5 minutes.
Oh, I'm sorry.
For the record, again, my name is Bruce Goldson, a representative for the applicant. During our investigation and preliminary design, we asked city staff the possibility of a major variance. And we were advised at that time that we could apply, but it was very unlikely that it would be approved. So we continued with the current transportation plan with the sidewalk and swale on our side of the street. At one point, we considered and asked the city, could we put the sidewalk on the other side of the street? And they said, no, that would not be acceptable. So we proceeded with our design, and it would be very costly now, even if you chose to move it on the other side. We've spent a lot of time doing our design, putting it on the side where the code requires it. I support keeping the trees if possible. However, reducing the pathway to 4 feet doesn't accomplish a whole lot. As I pointed out in our one sketch, if we're required to have, say, a 4-foot path, then we have 2 foot of clearance between the tree, the major tree, and the pathway. The roots, unfortunately, are much more extensive than 2 feet from the tree. In addition, there's a public storm system currently coming from across Goodall Court, heading our direction, that we must convey the stormwater to the end of the property. We've shown 2 options right now, and we may eliminate the storm drainage pipe if we can demonstrate that the swale is adequate to handle that off-site flow. We're not convinced that it will or will not at this point, so we've shown them both at this time. We've agreed with the neighborhood association it'd be very advantageous to keep the tree. Cutting trees down costs money as well. You know, if there's a way to go around it, we don't see it. The transportation plan is very clear. And the swale also provides water quality for Goodall Road. So that's the other feature that the swale provides. And that's why their typical design has that swale right next to the road. I think that's about the cross-section. I'll just point out that I have a cross-section, I assume it's in the application somewhere, that shows a typical cross-section that shows the ground upslopes from the existing road up to the right-of-way. And so we have to do some significant grading because the pathway is 2%. Width of the drainage swale is what it is, and it has a 2-to-1 slope or 3-to-1 slopes on both sides and the bottom, and a 3-to-1 slope past the pathway to the catch point, actually outside the right-of-way. And so that's why we're forced to remove the trees. Now, if a major variance could be supported by city staff, then we could consider other options.
Any questions? Thank you, Mr. Coughlin.
Thank you.
All right, now comments or questions among ourselves. Let's try to use the yellow button.
Again, before you move to deliberation, unfortunately, the statute procedure. Prior to closing the public hearing, any person may request an opportunity to present additional evidence. If a request is made, public hearing would either be continued to date certain, not less than 7 days. Darn, I lost connection.
Does that apply to this case because it's a tree issue, or It's because of
It's
the
land use
variances.
application. Let's see,
Are you looking for a calendar?
no. Well, does any person request the application, or request a continuance to present additional evidence?
No.
Hearing none. Does the applicant wish to continue the hearing in order to file a written argument which should not be considered part of the application, but which would be considered part of the record, but could not include any new evidence, but would delay the commission's deliberation?
No.
No. Now you may proceed to deliberation, Mr. Chair. I'm sorry to do that.
And I'm sorry. Thank you. Comments? Yes, Commissioner Dews.
Well, I'll just say that understanding there does seem to be a certain amount of sense about maybe taking the pathway and moving it over to the east side for that portion of it. However, what I'm hearing from the city is that there is a capital improvement for taking care of that area on the east at some point, and it sounds like in the not-too-distant future. And since you do need the sidewalks on both sides of the street, I think it's imperative that we just leave this with the development with the pathway on the west side. And, you know, slowly as other properties develop or come before the city, that portion on the west side will get developed as well.
Any others? Well, I would like to hear a motion to support, approve the recommendations from staff with the conditions that are in their report. And I will move that we accept the recommendations of staff.
I'll second that.
I'll second that.
Please call the roll.
Pingree,
Aye.
O'Connor,
Aye.
Dews,
Aye.
Bates,
Aye.
Leek,
Aye.
Mino,
Aye.
Lindstrom,
Aye.
7-0.
Right, these are tentative findings we brought back to the commission on the 19th, as I recall. So that has two findings come back before the commission. Are there any contested cases on the 19th?
There are no scheduled public hearings for the 19th, August 19th. So I would ask the commission if you want to meet at 6 p.m. and if you would like to meet online or in person. So we have those options in front of you to consider.
Yeah, this is your schedule and review. What you're saying is you do not have any other item for the 19th.
No other items on that agenda besides adoption of minutes and adoption of the findings for these two hearings tonight.
6 o'clock or 7? Who would like 6?
6 o'clock.
6.
6 o'clock, please.
I won't be present, so I don't care. Out of the country.
And would you like to do this online or in person?
Online? Okay.
Online.
All righty.
All right. Can you talk about other scheduling issues, Director Hasty?
Just for the record, so we're going to let the applicants know
Okay,
on the
yes.
first case, because we said, well, at 7 o'clock, you know, looked like it, because
Yes.
this could have been continued. We'll let them know it's at 6.
So the project planner, Daphne Sissel, will reach out to the property owners for the type 2 tree removal request for hearing and let them know when those findings will be adopted, that they'll be at 6 p.m. and online. Obviously, the applicants are here today and know that. So please do note that on August 19th, it'll be online, and we can send you a link to that Zoom meeting once we get that set up.
No testimony is allowed, just to set expectations.
Okay, this is just adoption of findings. And again, just to reiterate, I don't have anything else scheduled. So far, we do have some applications that may come before the DRC later this year, but nothing is complete, and no firm deadlines, or sorry, dates for those hearings are known at this time. So it is just meeting on the 19th for the minutes and findings. And I will let you know as soon as I hear anything else.
Thank you.
Thank you very much.
You're welcome. Thank
Hearing
you.
nothing more, meeting adjourned.